Okay, good afternoon, everyone. I'd like to begin by acknowledging the traditional custodian of the land on which we meet today and pay my respect to their elder, past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples. I also pay my special respect to all the fallen heroes from Spring Revolution in Myanmar and at last not the least to all our panel and participants from different parts of the world to join the AMI seminar today. Our AMI president, Christopher Lam, will open the meeting. Chris, the floor is yours.
Thank you, May Chair. And without further ado, I think everybody knows the importance of the International Court of Justice and the genocide case which has been brought by the Gambia. It's now gone into a new phase, as will be explained by the speakers, the first of whom is Binoy Kampmark.
Thank you very much, Christopher, and thank you very much to the panel and to all those who are listening onto this session. It's a pleasure being here. Yes, it's a very momentous occasion in terms of examining what's happening with the Gambia and also the context of the International Court of Justice and also the issue of genocide here. So I would like to just mention a few introductory remarks in the context of what the ICJ is, which, it has been pointed out to me that some people might not necessarily be clear about. So the International Court of Justice deliberates over disputes between states primarily. So it's important to realize that when we speak about these issues here, we're talking about disputes over states over matters of international law. This is the successor to the court, as it were, that was existing under the League of Nations, that also provided and generated a degree of international jurisprudence. But what is interesting about this particular instance is that we have a particular country that does not, on the surface at least, have any direct connection with the dispute, specific in this case to Myanmar and so forth, nonetheless bringing an issue before the ICJ. And the issue in this case, of course, is the question of deliberation of a genocide. Before I start, it's important to realize what significance this is in terms of what the term means. Genocide itself is a combination of words, ceda and genos. It is a Latin Greek combine that is the brainchild of Raphael Lemkin. Raphael Lemkin was a remarkable Polish bibliophile who spent long, arduous hours wondering about how humanity's cruelty, if you like, could be reduced, or not so much reduced, but to be understood in terms that could be legally determined. It was famously said, of course, just at the end of the Second World War, regarding the treatment, the appalling treatment of the Jews and the killing of the Jews that became known as the Holocaust, that this was a crime with no name. So Lemkin set out approaching the issue of the crime with no name and gave it this term, genocide. The birth of this, or the outcome of this, was the UN, or is rather the UN Genocide Convention on the Prevention and Punishment of Genocide. We'll call it for shorthand the Genocide Convention. And what is interesting about this are the elements of intention, of course. There has to be an intention to target a set group. The group itself must be based on ethnical, religious reasons and matters like that. But what is also fundamental to this, and that makes it, of course, very difficult sometimes, as I said before, the intention part. Now, fundamentally about this that's excluded, and that makes it difficult, it's the political aspect of it. So politics or political classes are excluded. It's not within the scope of my discussion today to go into that, but it's worth considering that that sometimes can be the weakness of this particular convention. So more specifically to what we're looking at today, genocide or charges of genocide have various limitations in terms of proof. I've already mentioned mental state, the intent. It's also evidential. How do we prove system? How do we prove that there is a system in play? The paper trail, if you like, it's actually surprisingly difficult when you start having to prove that. There are obstructions made by governments. There are obstructions, of course, in terms of naming the term. And this is not necessarily just from governments responsible for the abuses. We're talking about governments, for example, such as the US government, very reluctant to name in 1994 the fact that there was actually genocide taking place in Rwanda. Why? Because it commits then an obligation to intervene, suppress, and punish or prevent the particular crime. So there is a reluctance for that. In the context of the Gambian involvement here, we're talking, but this is where it gets interesting. Gambia may have itself, or the Gambia may have itself initiated the particular case, initially filing it in November 2019. However, it did so with support of the Organization of Islamic Cooperation. This raises some interesting points, which were also raised by the Myanmar government. And in the application, it actually stated that there were genocidal acts resulting in the killing, and I quote this, causing serious bodily and mental harm, inflicting conditions that are calculated to bring about the physical destruction, imposing measures to prevent births, forcible transfers intended to destroy the Rohingya group in whole or in part. So the classic definition there. The UN Genocide Convention permits member countries under Article 9 to hear disputes between the parties that deal specifically with the application of the convention. So how far would it actually go? Well, Gambia in this particular case, or the Gambia rather, made or argued that there should be provisional protective measures dealing with the issue of the Rohingya remaining in Myanmar. These would, for example, involve preventing genocidal acts against them, ensure that the security forces did not continue pursuing their acts, and then, of course, to take preservation measures regarding the evidence in that particular case. So in January 2020, the ICJ agreed with that particular request. And the Hague-based body further gave Myanmar a timeline of 4 months to report on the country's implementation of the order, followed by 6-month deadlines to monitor performance on that particular case. Now, Myanmar obviously, and you would imagine, responded with its objections. It argued, and these are the interesting issues of the case specifically, that there was no sufficient connection or jurisdiction between the applicant state, in this case, the Gambia, in terms of not having a direct link there with, of course, the context of their argument, but also, and this is the other thing that's important, that they were not the real applicant. The real applicant in this case was the Organization of Islamic Cooperation. But the interesting thing about this was that the judges, by majority, there was only one who decided, and actually that was the particular judge in question, Judge Sue Han Chin, decided to accept that the argument that Gambia was not really the applicant, he was in fact the OIC. But in the general sense, what the bench did, what the full bench did, or not the full bench, the whole bench bar the dissenting judge, accepted that the issue of genocide was essentially of such fundamental importance to the convention, to the fulfillment of its ideals, that it could, as it were, proceed in this particular case. I think it's very interesting in that sense because it reveals that other parties can bring applications within the ICJ jurisdiction and that it's not limited in that particular way. And a responsibility can therefore be assessed in that manner. The other thing too that the judges noted was the advisory opinion, not wanting to bore the audience about the specific legal dimension of this, but essentially was the reminder that genocide is considered the supreme or one of the supreme crimes. Ius cogens, it's called. It's so fundamental that it trumps other obligations in a sense. And for that reason, because it's considered of such a higher order, it assumes a kind of a property that needs to be respected in international law, and I would argue generally international relations. So The issue, of course, as a result of finding the particular provisional measures, is that it tends to go to the UN Security Council. But of course, as we all know with the UN Security Council, they then have to decide what to do. And we know that politically speaking, this is very sensitive. It raises then the broader problems of where we stand when it comes to enforceability of judgments like this. But it is worthwhile noting the significance, therefore, in this broadly speaking. Just in my last part, just a few minutes very quickly to emphasize this. In addition, let us not forget that the Gambia has made a significant move in this, but we should not forget other jurisdictional aspects here as well and efforts made to deal with the genocidal question. We have, of course, the investigations of the International Criminal Court, which have been activated since November 2019. It's an ongoing long process dealing with accumulating evidence with that. But there are also individual lawsuits that have been filed in the UK and in the United States. And so we've got, for example, applications made suing Facebook, dealing with the issue of genocide in terms of not taking down inflammatory, inciting material from the particular servers in question. That's very significant. There was a class action launched in San Francisco in December 2021, claiming that there was a business incentive here for not taking this down, and this actually imperiled the Rohingya. The other thing to also note is a lawsuit that was launched or filed before the Argentinian judiciary in November 2021, specifically against the Myanmar military. So it's worth noting that in that case, they also used the arguments of ius cogens, that is to say, this kind of law of universal value and importance that permits an investigation to be undertaken into allegations of genocide. So I would suggest that this raises various critical issues that the other speakers, I'm sure, will discuss, and we will elaborate upon, which are critical in the context of this discussion. Thank you.
Thank you.
Good. Thank you very much. Now, before we go to Jonathan Liljeblad, the next speaker, first, thank you very much, Binoy. That's very helpful. If you have any questions, I ask the audience, could you please put them into the chat room? And we will then consolidate the questions as usual for the panelists when the time comes. Jonathan.
Thanks, Chris, and thanks to Binoy and thanks to Catherine for being here as well. And I'm very humbled to be in such august company. Before I begin, I just want to note that I just want to acknowledge the fact that Vicky Bowman was arrested last week, and so in addition to the detention of Sean Turnell, that I see this as being indicative of the increasing level of desperation by the Myanmar military. But it does raise some cause for concerns as to then, if the military is becoming more desperate, then what are they willing to do? So I think this is deserving of much greater attention from the international community as a whole. So this evening, I just wanted to make 3 observations to add to what Binoy had noted. 3 major points. So in broad outline, the first point is respect to the response between the Tatmadaw and the NUG with respect to the ICJ proceedings, specifically the struggle as to who was going to represent Myanmar, the state within the ICJ. The second thing I want to mention is regards to the signals that the NUG has given with respect to the issue of the Rohingya crisis. And then the third is a bit of a cautionary tale, just some recent information that I've come across with respect to something that may pose a problem for the ICJ proceedings as we go forward. The first one, and this will probably take the greatest amount of time, is with respect to who gets to represent Myanmar within the ICJ. So the ICJ, in its jurisdiction, hears disputes between states. And as a result, when it renders judgments, it's always judgments against states. But the question is who actually represents the state within the actual courtroom of the ICJ itself. For both the Tatmadaw and the NUG, the National Unity Government sought to go ahead and take that position. And they did so out of the belief that having a position within the courtroom would actually have some connection to the struggle over recognition as to who would be the legitimate government speaking on behalf of Myanmar as a state entity. I just want to make some observations about this. There is some validity to this, but it is somewhat circuitous. And so my comment specifically relates to the fact that the ICJ noted that its jurisdiction applies primarily to states. And as a result, it did not extend to the question about recognition of government. And that with respect to the Gambia versus Myanmar, the question about the recognition of the legitimate government of Myanmar would be left to the United Nations General Assembly. And that includes the UN General Assembly proceedings regarding credentials for the seats within the assembly itself. Unfortunately, that decision by the ICJ did not provide a lot of clarity. The UN General Assembly does not have criteria regarding the credentialing of seats within the representatives for the seats in the assembly. The UN Rules of Procedure generally leaves the question about credentialing to the General Assembly itself to decide. Historically, the United Nations General Assembly had three competing doctrines in terms of how it dealt with the credentialing of representatives in the assembly. I'll mention here specifically, there was the 1930 Estrada Doctrine, which basically said that states recognize states. States do not recognize governments. There was the Tinoco Arbitration Doctrine of 1919, and this articulated the idea that recognition of governments was based on effective control of territory. And then there was the 1907 Tobot Doctrine, which raised the issue of legitimacy in the sense that an entity that comes to power through illegitimate means is not worthy of recognition as a government. In practice, starting in the 1990s, the UN General Assembly seemed to indicate that it was shifting away from effective control to this question of legitimacy. My concern, though, is that with respect to Southeast Asia, the UN General Assembly has manifested some measure of inconsistency. So I'll give you a summary of cases here just to indicate what I'm talking about. So Haiti, 1991, there was a coup that overthrew a civilian elected government. The UN General Assembly accepted the credentials of the deposed democratically elected civilian government. 1997, Sierra Leone, there was a coup that overthrew another elected civilian government. In that situation, once again, the UN General Assembly accepted the credentials of the deposed elected civilian government. Libya, 2011, this is a situation where there are actually two entities competing for recognition as governments. There was the Gaddafi regime and then something called the National Transition Council. In this situation, the UN General Assembly recognized the credentials of the National Transition Council. Contrast these cases with 1997 Cambodia. In this situation, there was another coup that overthrew a civilian government. And here the UN General Assembly deferred its decision. It chose not to make a decision about credentialing. There is an argument the UN General Assembly is comprised of its constituent members, and that the more influential members can help to direct the decision about credentialing. But here too, and this is where I do think there is some validity to the struggles between the Tatmadaw and the NUG with respect to representation. You can take as an indicative example the position of the United Kingdom. So there was a judgment in Somalia versus Woodhouse in 1982, where Justice Hobhouse said that the British government had four criteria in terms of how it recognized other governments. First, there was a question as to, did the entity come to power through a constitutional process? Second, did the entity exhibit some kind of administrative control over territory? Third, was there a practice by the British government to treat the entity as another government? And then fourth, what was the nature of international treatment of the entity claiming to be a government? And this leads us right back to a situation like the International Court of Justice and the treatment of the Tatmadaw or the NUG vis-a-vis the position inside the court proceedings. So on this one, it's a very political process. It's not a legal one. And this is where I do think that for those of us who are supportive of the NUG as an elected civilian representative of the Myanmar state, that we do want to pay attention to the reasoning and the approaches and the treatment that are exercised by entities like the International Court of Justice. My second point, and this relates to the NUG's position regarding the Rohingya and its shift with respect to the Myanmar perspective regarding the Rohingya crisis. It goes beyond what the NLD had done. The NUG has given signals that it is attempting to reform the Myanmar position regarding the Rohingya, and this is with respect to 3 dimensions. So to begin, the NUG has given signals that it wants to align itself with international norms on human rights. It has created the Ministry of Human Rights. It has called for international aid to promote human rights education within its membership, within the ministries. Most significantly, to me at least, is that it's seeking to increase awareness and compliance with international norms of human rights within the NUG Ministry of Justice. Continuing on, the NUG has indicated that it wants to promote diversity and inclusion. So we can see this within the composition of the ministries. So last I counted, 13 ministries had members that were coming from different ethnic communities. So this includes the Kachin, the Karen, the Chin, the Kaya, the Shan, the Dang. In addition, the National Unity Consultative Council, with respect to the new constitution, has sought to actively engage with ethnic armed organizations. And perhaps most significantly is respect to the Rohingya itself. So in June 2021, the NUG announced that it wanted to extend citizenship to the Rohingya communities. And then just 3 days ago, on 26th of August, 2022, the NUG issued a statement that it expressed shame and regret for Myanmar's treatment of the Rohingya, and that it encouraged the international community to promote justice with respect to the interests of the Rohingya as a people. My third point, and this is my last one, is a cautionary note. The proceedings of the International Court of Justice relies on evidence, as Binoy had noted. There's an evidentiary component, so this requires data about activities being committed by the Tatmadaw within Myanmar. A lot of this is tied in part to something called the United Nations Independent Investigative Mechanism. So the IIM, the Independent Investigative Mechanism, is an online resource where victims of the Tatmadaw can deposit information about Tatmadaw activities. This evidence is meant to be shared openly around the world to national and international judicial proceedings. The Independent Investigative Mechanism itself is cooperating with both the International Court of Justice and the International Criminal Court with respect to actions against the Tatmadaw. Within the past few months, however, there appears to be actual resistance by Myanmar communities against the Independent Investigative Mechanism. I don't know what's happened, but in recent discussions that I've had with people inside Myanmar, it appears that there's a belief or perception that the United Nations is actually working with the Tatmadaw. And this may be in part tied to the fact that there have been recent actions by UNESCO to engage with the Tatmadaw regards to education proceedings, and there are other UN-based humanitarian organizations that have been attempting to get permission from the Tatmadaw to get access for humanitarian operations inside the country. Regardless, there's been some situations where people have, as a result, become reluctant to work with the UN and to work specifically with the Independent Investigative Mechanism out of fear that the evidence will then be used to help the Tatmadaw identify and prosecute pro-democracy sympathizers within the country. This is quite disheartening for those of us who are involved in international law, international justice, and quite disheartening for those of us who do want to try and bring justice against the activities being committed by the Tatmadaw. How we resolve this, or ways to get around this, I think this is a matter for open discussion. And I certainly welcome any kinds of comments or observations on this particular point. So I'll stop my comments there, and I apologize for being about 30 seconds over time. So thank you.
It was well worth it, Jonathan. Thank you very much for that.
Thank you.
And now Catherine Renshaw will give her comments on this. She has a long history in Myanmar and with law and human rights in the country. Catherine.
Thanks, Chris. I'm speaking to you from Camaragal land here in Sydney, and the land was never ceded. I pay respects to the traditional owners of the land and acknowledge that the project of justice is an ongoing one, to which we're all committed here, I'm sure. And just the work of the Australia-Myanmar Institute, both before the coup and since, has been so important to those of us who care about what's going on in Myanmar. So thanks for this event, Chris and May and everyone involved in the Institute. It's terrific to follow up on two such informative presentations about these really important legal proceedings. And before we go to questions, I just wanted to highlight a couple of things that both Binoy and Jonathan drew attention to. Binoy talked about the International Court of Justice. It's also known as the World Court, the court where disputes between states are heard. And Myanmar signed the convention that this is all about, the Convention to Prevent Genocide, way back in 1956. The convention itself is the earliest international human rights treaty. The same year as the Universal Declaration of Human Rights was signed, we had the Genocide Convention. It is that important to the world, this convention. But the number of cases that we have had on this convention are very, very few. We only have one judgment on genocide, and that, as Binoy said, was a finding that Serbia had genocide occur when there was the murder of 8,000 men in Srebrenica. And the finding in that one judgment we have on genocide wasn't that the state itself had committed genocide, it was that the state failed to prevent genocide from taking place. So we're in uncharted legal waters here. As Binoy said, there are complex legal issues that are going to have to be thrashed out before the International Court of Justice, and it's not going to be easy. But the decision that we saw a week ago was hugely significant. The dismissal of the objections that Myanmar's military had put before the court, saying that the court had no jurisdiction to even hear this dispute, saying that the real party wasn't the Gambia, it was this shadowy organization funding the Gambia, the Organization of Islamic Cooperation. All of that the court dismissed. So it's an incredibly important and welcome step forward for justice, the decision handed down by the court a week ago. I think an important point to make is the question of time, though. So in the other genocide case that we have had in the International Court of Justice, it took a very, very long time, 15 years, to get from filing the initial application to a final judgment. So that is far too long for the Rohingya to endure. So that's a cautionary tale. I don't think these proceedings will take that long, but we shouldn't expect quick justice that will solve political problems from the International Court of Justice. We can, however, expect some of the evidentiary problems that Jonathan referred to at the end of his talk to find a good, firm basis, despite problems that the independent investigative mechanism is having currently, in the work that's already been done collecting evidence about what happened in Rakhine State in 2017. So very quickly, by UN standards, in the wake of the horror of August 2017, the United Nations Human Rights Council set up an independent fact-finding mission, and Australia's Chris Sidoti was on that. And they gathered and produced in fairly swift time a really high quality, well-verified, a mass of evidence that can be used and that form the basis of what the independent investigative mechanism is still building on and working on as well. So that's a positive thing for the International Court of Justice proceedings. And two things that came out of all of that evidence that will be helpful and that give people hope when they're looking at these International Court of Justice proceedings and thinking about how complex it is that there was evidence that the state was a part of inciting the commission of acts of genocide, and that the long history of denying and depriving legal rights to the Rohingya over many years, constraining the ability to have children, to be married legally, all of that could be used as evidence that the state intended to commit genocide as well. So as Binoy said, is a complex issues, but this is a case that legal advisors watching it have a lot of confidence in. Something that we need to think about are the provisional measures that the court ordered back in January that Binoy mentioned as well, that every 6 months, Myanmar would have to report on what it was doing to prevent further genocide from taking place against the Rohingya while these proceedings ran their course. Now, before the coup, we had evidence that the government was in fact handing over reports to the International Court of Justice. Unfortunately, these reports were secret, though the legal representatives of the Gambia got to see them. But there was compliance, for what it's worth. Since the coup, we haven't got evidence that there's been compliance with the reporting obligations in the International Court of Justice. So that's problematic. In terms of the other proceedings that are currently on foot in the International Criminal Court and under the principle of universal jurisdiction in Argentina, in Turkey as well, they're being viewed less as a problematic cause of conflicts between different proceedings and more as a patchwork of accountability. So the International Court of Justice is looking at Myanmar as a state. What did the state do to allow the Tatmadaw to carry out these murderous acts? And what did it not do that it should have done to prevent them from taking place? The International Criminal Court is looking at personal accountability of the Commander-in-Chief, of Min Aung Hlaing and others in what they actively did, giving the orders that allowed the atrocities against the Rohingya to take place. Jonathan and the discussion about credentialing is incredibly important. And again, it's really a legal case of uncharted waters. Again, I was trying to think of a better phrase, but it would be a big mistake to think that this is just of interest to lawyers. It's a technical, legal, technocratic dispute. It's absolutely not. What's at stake with the credentialing question, who is the legitimate representative of Myanmar right now, the National Unity Government or the Tatmadaw? Everything turns on that. Right now, we have $1 billion that has been quarantined by the US in US banks that is owned by the state of Myanmar. Now, who is the legitimate representative of that? because they are the people who are entitled to access that money. And the Tatmadaws' ability to fund the ongoing massacres and crimes against humanity in Myanmar post the coup depends on being able to access funds. On the other hand, if the National Unity Government was able to access the money, well, they've made quite clear what they would do with it. They're basically providing the only semblance of what a government should be doing right now in the country: the provision of humanitarian aid, the provision of treatment for COVID, what there's left of education. It's the NUG, sometimes in cooperation with ethnic armies, that's providing it. So it's not just who gets to stand up in the International Court of Justice, it's who gets to access the bank accounts. There's also a suggestion that if the National Unity Government were recognised as the legitimate government of Myanmar, well, that would entitle the NUG to formally ask and to receive foreign intervention, direct intervention in the form of at least humanitarian assistance. And I mean, it's arguable that anything more than that wouldn't be prudent, but it could at least directly request and get humanitarian assistance. In the early days following the coup, there were those heartbreaking scenes of people in Myanmar holding up signs saying responsibility to protect, where is the world, when the most obvious violations of human rights are occurring and the government is slaughtering its own people. And if the National Unity Government were recognised as the legitimate government, then the case for R2P would be all the stronger. And just a final point before we go to some questions. On Jonathan's really important analysis of the NUG's increasing recognition of the Rohingya, will to give them citizenship, a path of true pluralism and inclusion. It's not just the NUG, is it, that is demonstrating a change in attitude towards the Rohingya. And we've seen from across Myanmar, ordinary people at local levels saying, prior to the coup, we believed Aung San Suu Kyi when she said what was happening to the Rohingya wasn't real, it was an avalanche of misinformation, etc., etc. And now ordinary people are saying, now we understand what was done over many decades to the Rohingya because it's being done to us now. So I'll leave it there, Chris, and I can see that there's been lots of questions, so we can move to that.
Thank you very much, Catherine, and we will move on. It's been really interesting to listen to you and to the two other speakers, Binoy and Jonathan. I think that they've provided a very good base for some lively questioning, and some have been submitted already, as you will have all seen in the column, in the chat column. Could you please, maybe Catherine, elaborate on what you said about the International Criminal Court and the International Court of Justice? What's the practical difference in terms of outcomes of what might come out of those two courts?
Yeah, so with the International Court of Justice, we have got proceedings on foot. Things are underway. The Gambia, representing the interests of the Rohingya, has filed its memorandum saying what its case is. Myanmar's objections to the whole proceedings have been ruled out of court, so it now has to respond to the Gambia. So there will be a decision from the International Court of Justice. They are solid proceedings. It will be a decision that says something about Myanmar, the state. But when it's making a judgment about Myanmar, the state, and what it did or didn't do to prevent genocide from occurring, it will inevitably, the International Court of Justice, make findings about what occurred on the ground, about what atrocities took place. We will have a record of what happened from the court, and we will have that judgment. So they are far more certain a set of proceedings than what we have in the International Criminal Court. The International Criminal Court is completely different in that it's directed to individual criminal accountability. So the actual people who gave orders to demolish villages, to round up people, to commit atrocities, the commander-in-chief and anyone under them who carried out murderous acts, they're the target of the International Criminal Court. But there's a couple of problems with actually getting a trial before the International Criminal Court, which right now is just authorized to an investigation. That's all that's happening in the International Criminal Court right now. And the big problem we have is that the International Criminal Court will only have a trial when it has a defendant in the dock. So you can imagine that the kind of circumstances where we have those most responsible for what was done in Myanmar, the commander-in-chief, in a dock in The Hague, are quite rare. There is so much that would have to happen before that. An international arrest warrant would have to be issued. We would have to have him leave the country probably, and a country that was sympathetic to the International Criminal Court would have to arrest him. It's more likely that those lower down the hierarchy would find themselves in The Hague facing ICC proceedings than those most responsible, Min Aung Hlaing. But both sets of proceedings serve different purposes. The International Court of Justice between states, the whole world is behind the Gambia, saying that Myanmar has breached the Genocide Convention. Then the International Criminal Court proceedings targeting the individual after a long process of investigation. If it ever gets the right people in the dock, we would have a judgment.
Binoy spoke about the decision by the court just now, and the 15-1 or the full court decisions, depending on which ones you looked at. This means that the judges who took a view that the case should proceed included the Russian judge for a start, and other judges from countries that might not necessarily have normally been seen as friendly to the NUG or unfriendly to the SAC. How do you see this all coming down when the court takes the formal proceedings? And I think it's in late April, is that right, when that starts? Binoy?
I think, yes, I think so, Christopher. So, I mean, the point, look, I'm not going to guess about how these sort of things go. I think what was interesting is to sort of see how it proceeded to this stage in the first place. And so the fact that it got this far is very interesting. And the fact that there is an acceptance about the principle of it is very remarkable. And I think that's the key. So rather than sort of wondering where it now falls, the issue is that we now know that this can be taken, that the actions can be taken in regards to pursuing the interpretation and the application of the UN Genocide Convention. That is the revolutionary thing about this. As to findings, I'm not going to venture into the politics of it, because let's face it, that's going to also feature in the background there. But in terms of the steps and the jurisprudence here, there has been a significant change. And I think that's something that we should take heart from. It's one of those things that's very difficult, as I said at the start, in general cases to prove genocide. It's a very difficult crime because, one, it's of such a high order. It is complicated in terms of evidence. It's complicated in terms of the mental state. It's so difficult to show that, even with the atrocities and the former the criminal tribunal, of course, for former Yugoslavia, and with Rwanda, the jurisprudence there shows how difficult it is to get a verdict for genocide. So As to what the ICJ finds, I'm not going to speculate about that other than to simply say that getting this far was remarkable and something that we should appreciate very much in the community, as it were.
Chris, can I add just a little bit to what Binoy just said?
Yes, please do. Yeah.
The other International Court of Justice genocide case, the Serbia case, we had criminal judgments from the ICTY that were used by the International Court of Justice as their basis for evidence. And we're doing it the other way around, really, with Myanmar. So that presents more of a challenge for the International Court of Justice. It won't have any decisions from international criminal courts to use as its evidence of intent and intention to destroy in whole or in part. I mean, even like Binoy referred to that, the Genocide Convention says there has to be intention to destroy in whole or in part. And already in some of the preliminary proceedings in the International Court of Justice, we heard the lawyers for Myanmar say, you know, how can it be that there was intention to destroy in whole or in part? Most of the Rohingya are still alive, you know. So, I mean, there will be much more to be argued out in the court.
Thank you. Taking that point and back to things that you said yourself, Catherine, so far as we all understand, the Myanmar government did its 6-monthly reporting to the ICJ after the initial protective measures were put in. But then they may have stopped after the military takeover. How would the court be likely to handle that in the absence of further evidence that it could use when making a decision about whether the crime had been committed?
Well, it shouldn't affect its ability to decide about the past, about whether there was a failure to prevent genocide or intention to commit genocide. But it shows that Myanmar is breaching the current orders of the court, which is a very bad thing to do, and which should go to the UN Security Council, which is automatically notified of orders that the International Court of Justice makes. But I think Jonathan talked about problems in the Security Council with China and Russia vetoing any action in relation to Myanmar. So that is a really good point, and one that we should bear in mind. There was a question about, well, what could be the ultimate outcome of International Court of Justice proceedings? I mean, there would be a finding, there would be a record of history, there could be an order for compensation, but everything depends on enforcement, which ultimately depends on the Security Council. And we've seen the Security Council hamstrung by the powers on it that have a permanent veto, which is Russia and China.
That's right, that's right. And we'll have to wait and see. Let's just, I want to bring a question to Jonathan, because we're going to run out of time if I don't do that now. How much of the people in Myanmar are aware of the fact that the ICJ has reached this conclusion on procedural issues? I know the military have put out a statement rejecting what the ICJ has done, but does anybody there, including in the legal fraternity, have any real clue about what this is all about and where it's going?
Well, yeah, so admittedly, you know, my information is based on the people I talked to and the people I worked with in the past within the legal community there. And incidentally, not just within private practice, but also even within the Attorney General's office and the judiciary. The answer is it depends on who you're talking to. It depends on where in Myanmar you're discussing these kinds of issues. The finer legal points, the technical aspects of litigation, not just within the International Court of Justice, but the International Criminal Court, international law as a whole. These are things that are incredibly sophisticated. And so it's not something that the average person on the street in Myanmar would really have a lot of awareness of. They understand that there are proceedings regarding the Rohingya in the International Court of Justice, and this is very much in the abstract. But in terms of the details, the proceedings, the ramifications, the legal arguments, this is something that's not going to be, common. Among lawyers, there's an awareness of the general analogies to domestic law procedure that is exercised by the International Court of Justice. So these includes things like provisional measures, which are analogous to injunctions, the need for evidence gathering. So this is very much something that any lawyer would be aware of. The question of causation. So again, it's at least as it's under the ICJ, this is analogous to something that domestic law is aware of. But as to the actual rules that are exercised by the ICJ, the formal procedures, this is something that you're not going to find a lot of widespread awareness about these kinds of issues. Whether or not there's expectations or an awareness as to what, aspirations about some kind of a positive result, given everything that's happened since February 2021, my general sense, at least with the people that I've spoken to within the NUG, and at least with the family that I have who are in the country, there's a growing level of disappointment, I guess is the polite word, with the international community. In the early days after the coup, there was incredible level of hope regarding the integrity of international justice and the integrity of the international community in its statements regarding the promotion of human rights, rule of law, these kinds of concepts. And I think in the time since February 2021, and as time has gone further on, particularly given everything that happened with ASEAN and given the relative lack of action by the West, I think there's a general sense of disillusionment at this point that they've run into the buzzsaw of politics and the ways of Machiavelli, and that states always act in their own interests. And so I think that there's a certain level of frustration right now. So I'll leave it at that.
Thank you. Now, Binoy and Catherine, I'm not sure, you might both have an answer to this, and it might be easy anyway. How does a state which wishes to intervene in the trial do so? There was a report the other day that the UK were planning to do that, for example. And I think there are probably some other countries that have either the same plan or have already done that. Can you give us, either of you, give us anything on that?
Well, I can just quickly say that it's a process that's permissible under the system, by which states can join, and it's part of this idea of comity within the way the ICJ works, where other countries may want to add their application to it because it's a issue of significant concern. And well, it's very hard to question that this is not an issue of international concern. So if countries wish to therefore add to it in the context and provide support and so forth, this is a very important thing. But of course, that's very good as a facility, but it does come with its, well, Jonathan said, it's one of those sad things with the political tendencies of states. It's one of those tragic things in this field that states will, of course, have their interests, and on the surface, it looks like an aspect of solidarity, but you always have to be mindful of the fact that these kind of things can also have their political elements as well. But the mechanism is there because genocide is considered one of the, well, if not the highest crimes, certainly one of the highest crimes, and participation from states to determine the status of it, and it's whether it's been committed or not, is a very important question. So states would do well to get on board, certainly filing and being involved, and yeah, in that sense, that's how I'd summarize it. I don't know how Catherine may have additional things to say to that too, but that would be my perspective on that.
Yeah, no, that it's probably the easier part of the whole story to file the application to intervene. So the more difficult part is everything Binoy laid out. It's the political considerations. But I think the Maldives has said it's going to join. Canada, the UK. The US is a bit, I'm not as clear on the US position, though I think we should all note that the US did come out and formally, after its own investigation, declare that a genocide had taken place earlier this year. So that's a very important thing, I think, because if there is recognition that genocide has taken place by a country like the US, there flows from that a legal responsibility to do things, including to make sure that further acts of genocide don't take place. So that was not nothing, regardless of whether the US joins the ICJ proceedings.
Good, thank you. This takes us back to, and I think we've got very little time, so I'll be quick with this question, but it might be one that you all might like to make a comment on. It takes us back to the issue of recognition, which is raised by several people in their chat questions. If Australia and lots of other countries don't recognize governments, but they do recognize states, the judgment of the International Court would be delivered on the state of Myanmar. This raises the question of how anyone would expect that to be able to be enforced, if it were a judgment that should be enforced, without the Security Council taking a position on who was in charge in Myanmar. What do you think are the practical outcomes of all this, and what does it mean in terms of the recognition debate? Binoy.
Well, just very quickly, Christopher, the issue of recognition is often, it's not necessarily determinative of the practical aspect of what happens. In international law, it's a strange beast. You can still not recognize governments, but practical things can still happen. So there's a whole string of decisions in international law and between states regarding the status, for example, of the German Democratic Republic during the Cold War, which was not recognized for a time, but there were still legal things done in the context of what it was doing with, say, West Germany. Issues in terms of the status of government, whether the government has been overthrown, whether there's a kind of a flux. The decision can still take place, the effect can still happen, but of course the issue practically is the enactment of things. So states can still respond and do things relative to the country at hand. The decision can still stand, but the practical aspect of it is another story. It's the old problem about do we acknowledge this, but we still deal with what we have to do. Yeah.
Thank you. My memory is that a decision taken would need the Security Council to bring the states into line to do anything at all, but the decision itself would bind the United Nations organization. Is that right, John, Binoy or Catherine?
Well, just notice, Catherine in a minute, but the thing is, we've seen from previous ICJ decisions that irrespective of the outcome of that, it's regarded as binding, but that doesn't mean that the states follow it too. So that's the point. I mean, the Nicaragua decision there with the mining of the ports and the decision outcome is a famous case with the United States where the issue there became an issue, a problem in terms of that outcome. But I'll let the others, fill you in on some of the details. But the point is the decision is there, and I think it's important that it is there. And then the issue is the practical aspect that follows from that.
Thank you, Catherine. Do you want to add something on that?
I think Binoy deftly covered a really tricky, complex question there. So I might not further muddy the already muddy waters.
Well, in that case, Jonathan, would you like to add anything else? And then we'll close. And I'll also thank the audience for very interesting questions that were posed.
Yeah, I mean, the one thing I would add is that, and this is me speaking as an American, unfortunately, that there is a distinction between the actions of the UN as a collective entity, actions by ASEAN as a regional entity, and then actions by individual states. right? So states are in control of their own foreign policy. States make their own decisions about, whether or not they comply with the decisions of the International Court of Justice, or they comply with the directives or the instructions of the UN. And the only reason I'm mentioning this is that I will make note of this is that the United Nations has taken a lead. I mean, the United States has taken a lead on sanctions against Myanmar, and that the United States is the entity that's been driving a lot of the international efforts to initiate actions against the Tatmadaw, in collaboration with the United Kingdom as elsewhere, and that Australia, for its part, has actually been a little bit reluctant to exercise some of these actions, and has been a little bit reluctant to follow the lead of the US in this regards. So Australia, I respect its compliance with international law. I respect its compliance with the International Court of Justice. But I would make note that there is a certain level of autonomy that is available to Australia as a state to further and make its own foreign policy decisions regarding the promotion of democracy and human rights within its neighborhood of Southeast Asia. So I'll stop there. Thank you.
Okay, thank you very much. And that we are now past the hour, and so we need to close. But thank you very much to the three speakers for your presentations. It's really interesting to see this. Of course, we're talking about the Rohingya because that's the case. That doesn't involve a discussion about the wider issue or the separate, but very closely connected issue of widespread violations of human rights within Myanmar. And there was reference made to that during the hour. But thank you very much for what you said. The next of our seminars will be on Monday, the 26th of September. So block your diaries and we'll provide that information when we get there. Thank you.
Thanks, Chris.
Thank you, everyone.
Okay. Thank you.
Have a
Yes,
good
thank you, everybody. Thank you. That was wonderful. Thank you.